Hi, everybody, and welcome to another episode of Logically Speaking, our everything about law and Florida legal topics and Florida running a Florida law firm business live show. Tonight's topic we're going to talk about in the topic of criminal law, first appearance court, or as I stated in the explanation to tonight's show, is what happens when you get arrested. When do you go see the judge? What happens? Do you really have to wait over the weekend or on holidays before you get to see a judge? And then what happens when you get there? So when you get arrested, the first thing that happens after you're arrested and booked into the jail, as far as the first thing that happens in court, is you have what's called a first appearance hearing. And that first appearance is where you're going to go see the judge. And the judge is going to inform you of what you've been arrested for, what the allegations are against you. So, when does that happen? Well, under Florida law, you have to see a judge within 24 hours of your arrest. So that means that if you were arrested on a weekend or on a holiday, a long holiday weekend or holiday break, you do not have to wait to see the judge. You don't have to wait until Monday, and you don't have to wait over that long holiday break until courts resume before you see a judge. There are duty judges that are on duty on weekends and on holidays because you are required under the Florida rules and Florida laws to see a judge within 24 hours of your arrest. So you will go if you don't already have a bond placed at the time that you're arrested, because there are charges and bond schedules that we have in Florida that will tell the booking agent at the jail what certain bonds can be on certain charges. So if you get a bond set at booking at the jail, you are able to go ahead and bond out. And if you bond out within that, before that 24-hour time frame, you will not go see a judge, and your case will just progress through the court, as I'll talk about in another episode, through the arraignment and pretrials and things that would go on from there. But if you have not bonded out within 24 hours, then you would go and see the judge. And the judge would address your bond amount, and whether if you're arrested on a charge that requires an initial no bond until you see the judge, and there are some charges that require that. For instance, like domestic battery requires a zero bond until you go and see the judge within that 24 hours to address your bond conditions. And then certain higher level felonies like the murders and some of those types of cases require an initial zero bond until you go and see a judge to address those conditions. But and if you haven't bonded out on any of the charges then that do get a bond set on them, then the judge is going to, one, as I said, tell you what the allegations are, what you were arrested for. Then the judge is going to address your bond status, and he is going to set a bond amount for you to bond out with. And you can bond out several ways. One is a cash bond, where you pay the total amount of the bond into the clerk's office, or you can use a bondsman, where you generally put up 10% of the amount of the bond, so that you would work that out with a bondsperson. And so there will be a bond financial amount that is placed, and the judge will also address any other conditions of your release at that hearing as well. So some other conditions, for instance, that the judge can put on you as a condition of your bond, or a condition of your pretrial release, as it's called, is if there is a victim in the crime, for instance, like domestic batteries or things like that, the judge can order no contact. So the judge can order no contact with co-defendants. If there's co-defendants, no contact with the victim. The judge can order no contact with a location. Many times on theft charges, the judge will order no contact, and that you can't go to the location where that occurred. The judge can also order things like the GPS monitoring, the ankle monitoring. The judge can order things like no alcohol, and can order alcohol monitoring if that is something that pertains to potentially the situation. So there's any numerous amount of things that the judge can put on your conditions of bonding, conditions of pretrial release, in addition to any monetary bond. The judge can also determine that you can be released on what's called a release on your own recognizance, which means that you do not have to pay any cash bond to get out, or to pay a bondsman, but the judge is releasing you essentially on your promise to appear in court. And those types of bonds, where it's called ROR, or release on recognizance, where you're ROR'd out on your promise to appear in court, are generally for lesser misdemeanor types of crimes, and generally for people who have never been arrested before, and so have no prior record, and have connections into the county and the state of Florida, and they're not a flight risk. Those types of things that get considered on an ROR release. And so from there, then the judge sets those conditions, and then you are able to bond out on the monetary bond, and you must comply with any other conditions that the judge put on that condition of bond and pretrial release. And if you don't comply with those conditions, then you can be rearrested for violating conditions of your pretrial release, and then your bond can be completely revoked, where you would have to be sitting in custody with no bond pending the outcome of your case. So that is first appearance, and what happens after you're initially arrested, and when you get to go and see a judge, and what happens at that first appearance hearing. I'm attorney Siobhan Olivero, a Florida licensed attorney, and this is, of course, first appearances under Florida law. If you have been arrested or have any questions, please feel free to contact us at 813-654-5777, and we are here to help you and answer any questions you may have. See you next time.